Here we are again. In this subunit, we're going to discuss the excuses of impossibility and impracticability. Let's quickly refresh our memory about our excuse doctrines. Remember, excuses are performance defenses. It's a good way to think about them. We've already talked about mutual mistake and unilateral mistake in our previous subunit, and in our future subunit, we'll talk about frustration of purpose. In this subunit, we want to talk about the very closely related doctrines of impossibility and impracticability. All right, here's our setup. The law is that a party is excused from her contractual performance if her performance becomes impossible because of some supervening event beyond her control. Remember, in impossibility and impracticability, we're looking for something that happens after the parties enter into a contract that affects their performance thereunder. The doctrine of impracticability is that a party is excused from her contractual performance if her performance has become impracticable because of some sort of supervening event that was out of her control. And remember, impracticable means excessively costly, unreasonably more expensive. Let's talk about the doctrine of impossibility. The doctrine of impossibility will be implicated in four basic fact patterns. And these are the fact patterns: the death or incapacity of the promisor, the destruction of the subject matter of the contract, the unavailability of the subject matter of the contract, or if the performance becomes illegal. First, let's talk about death or incapacity of the promisor. Impossibility is only a valid excuse in this situation if the contract was for personal services. What's a personal services contract? Well, where we need the performance of that party, the party who has either died or has become incapacitated. For example, if I'm a famous singer and I promise to sing at your concert, and then I die or I become incapacitated, I have a good excuse for impossibility. Right? But if I'm a house painter and I promise to paint your house, and then I either die or become incapacitated, I don't have a good excuse for impossibility. There is no reason why you needed me to paint your house, and I couldn't delegate that or subcontract that out to some other party or get an employee to do it. House painting is not a personal services contract. Singing, having a famous singer come sing at your concert, that is a personal services contract. Destruction of subject matter, right? This is only a good excuse. You only have a good excuse of impossibility when we agree to a specific object or subject matter. So, for example, if I agree to sell you the Mona Lisa and the Mona Lisa is destroyed before I can deliver it to you, well, then I have a good excuse for impossibility. But if I agree to sell you a bowling ball, and as I'm taking that bowling ball off the shelf, I drop it and it is destroyed, I don't have a good excuse for impossibility. I can get another bowling ball for you someplace else. Unavailability of subject matter. Sometimes someone promises to sell something to someone and they plan to get it from someone else. So if I'm selling you goods, I might get those goods from a supplier. If I'm selling you land, I might not own the land and I might get it from someone else. Well, what if that land or those goods become unavailable before I can get them to you or get them for you? Well, it really depends on whether I have a good excuse for impossibility depends on why the subject matter is unavailable. This is one of those situations where the party who is claiming an excuse may indeed bear the risk that that subject matter becomes unavailable. And finally, the performance becomes illegal. There are times where parties enter into a contract, and when they enter into the contract, the performance of the parties is legal. But sometime afterwards, the law changes or circumstances change, and performance becomes illegal. In those circumstances, either party will have a good claim of impossibility. I cannot perform under the contract because my performance has become illegal. It is impossible for me to perform. All right, continuing on with the basic idea of impossibility. For impossibility, and we've already discussed this idea, there has to be a supervening event. After the parties have entered into the contract, something happens that results in one of the parties' performance becoming impossible. Okay? It has to be something that is out of control of the party that is claiming the excuse of impossibility. So just an example, some sort of fire or flood. Was the fire the responsibility of the person who was claiming the excuse of impossibility? Is the fire or flood something that could have been prevented with normal measures and the party didn't take those normal measures? These are questions we need to ask to determine whether the party will have a good excuse of impossibility. In the case of the subject matter becoming unavailable after the parties entered into the contract, why did the subject matter become unavailable? Was there some sort of war or natural disaster that caused the subject matter to become unavailable? Or did I just fail to get it? Or did my supplier go out of business? And maybe that is something that I should have taken steps to protect myself from. In other words, if the subject matter becomes unavailable, the party who is supposed to get that subject matter may bear the risk that that subject matter became unavailable. When we talk about the UCC approach to impossibility and impracticability, we'll further explore this idea. When the subject matter, when goods that I had planned to get from a supplier become unavailable, and now I cannot give them to you. I cannot fulfill my obligations under the contract to sell them to you because I couldn't get them from my supplier. We'll talk about that in subsequent subunits. All right, let's switch gears slightly and talk about the excuse, the doctrine of impracticability. Remember, the challenge for the law student in all of our excuses is to determine whether the party claiming the excuse should bear the risk of whatever happened. In mutual mistake, should that party bear the risk of the erroneous belief? In impossibility, impracticability, and frustration of purpose, should the party bear the risk of the consequences of the supervening event? When we were talking about impossibility, there were limited circumstances where you could claim impossibility, but you still had to consider whether the party claiming the excuse of impossibility should bear the risk of the consequences of the supervening event. When we talk about impracticability, we're expanding the circumstances because it is no longer merely about whether your performance became impossible. Your performance is possible in these situations. It's just become so much more costly. And then, because we're analyzing the whole idea of a cost structure, the risk analysis becomes even more crucial than impossibility, right? You can still perform, but it'll cost you more. Should you bear the risk of those extra costs that are created from the supervening event? All right, here's the rule. I am actually going to read this because I don't have it memorized. Of course, I have the concepts memorized, but I don't have it memorized word for word. So, a party's duty to render performance under a contract is discharged if her performance was made impracticable, and we know what that means, right? It just means more costly, not impossible, through no fault of her own, right? Fault is an important issue in impossibility and impracticability and frustration of purpose. By the occurrence of an event after the making of the contract, remember we need a supervening event, the non-occurrence of which was a basic assumption underlying the contract. The parties had assumed that this event would not occur unless the language of the contract or the circumstances indicate that the party claiming the excuse should bear the risk of the consequences of the supervening event. Let's go through each of these elements one by one to kind of flesh out what they mean. All right, our first element under impracticability is that her performance was made impractical. A party that is seeking the protection of the excuse of impracticability says, my performance has become impracticable. We know that means that it becomes more costly, but the question is, how much more costly? What line do we cross where a court will say, this is not impractical because it's more costly, but it's not so much more costly, and this, when you cross this line, this is now impracticable because it's so much more costly. Well, there is no line. The court are generally requiring the expenses to be several times more costly, not just a percentage like 20%, 30%, or even 50%, several times more costly than the original performance. I know it's a very hard standard to apply, but once again, you do a good analysis and you look at exactly how much more it costs the party to perform after the supervening event, and the best you can do is kind of estimate what you think a court will do. I like to say that the added cost has to be substantially or shockingly more burdensome, right? The performance after the supervening event is not just more costly, and it doesn't mean simply that I won't make a profit or I'm going to suffer some loss. It has to be shockingly more costly than the original performance, right? And all of this is related to the concept of risk. If I'm doing business or if I'm promising to do something, the other party is not guaranteeing that I will make a profit or that I will not suffer a loss. I should bear the risk of certain supervening events if the cost isn't too much. When it becomes shockingly more costly for me to perform, neither of us would assume that I would bear that risk. All right, let's look at the next element or group of elements in our rule for the excuse of impracticability. Remember, the whole idea is that a party's performance under a contract has become impracticable through no fault of her own by the occurrence of an event after the making of the contract. So let's explore these ideas. First, you have to ask yourself, did the event happen after the parties entered into the contract? Remember, impossibility, we're looking for some sort of supervening event. If it was an existing condition when the parties entered into the contract, but they didn't discover it until after they entered into the contract, well, that is an issue of mutual mistake, not impossibility, even though the doctrines are very similar. Was the event outside the control of the party claiming the excuse? Sometimes the party caused the supervening event, in which case the event was her fault, and in most circumstances she will not be entitled to protection under the doctrine of impracticability. Did she contribute in any way to the occurrence of the condition? And another question you should ask yourself, could she have prevented it? Could she have prevented the occurrence of the event? Or maybe she couldn't prevent the occurrence of the event in the case of, say, some sort of natural disaster, but she could have and should have taken some low-cost measures to mitigate the effects of it or protect against the consequences of the event. These are all things you have to ask yourself when you're doing an analysis of impracticability. Look in the fact pattern for facts that will give you some sort of insight into how a court might decide these elements. All right, let's move on to our next element in the doctrine of impracticability. And that element is that the non-occurrence of this supervening event was a basic assumption of the parties when they entered into this contract. In other words, the parties assumed that this supervening event would not happen when they entered into the contract. This element is critical to our risk analysis. Remember, when we're looking at any of these excuses, we're asking ourselves whether the party who is claiming the excuse should bear the risk. In mutual mistake, it's the risk of the erroneous belief. In impossibility, impracticability, and frustration of purpose, it's the risk that this supervening event would occur. All right, so it has to be a basic assumption of both parties that this supervening event would not occur. And this basic assumption doesn't have to be a conscious assumption. In fact, in most cases of impracticability, this basic assumption is an unconscious or a subconscious or an unspoken assumption. So, for example, we enter into a contract for you to sell me your house and I will purchase your house. When we enter into this contract, we are not consciously assuming that a tornado is not going to destroy your house sometime between when we enter into the contract and when you are able to deliver the house to me. Right? This is not a conscious assumption. We never say this specifically. We don't write this into the contract. There's just no need. But are we assuming that this is not going to happen? Yes, we're assuming that a tornado is not going to happen and destroy the house before we can consummate the transaction. But think about how many other things we are assuming will not occur before we consummate the transaction. There's a whole plethora of things way deep in the back of our mind that we're assuming are not going to happen, but we never even really consciously think about them. Those are usually the best cases for the impracticability doctrine. Now, there are certain things where we expect that one of the parties should bear the risk. So market changes, interruptions of supply sources, these sorts of things are business risks. And we expect the parties, in this case the party claiming the excuse, to bear this risk unless the market changes or interruptions in supply source occurred because of something very beyond the foreseeability of the parties. War, embargo, those sorts of things. So here's an example. Let's say that I'm a house painter and I contract to paint your house. Before I can do the job, several of my key employees, they leave my employment and they go work for the competitor. And now I have no one to paint your house. Do I have a good excuse of impracticability? Well, think about this. Let's just talk about it in the sense of risk. Whose risk is this? Who should be bearing the risk of my employees leaving my employment? Me, the house painter. I should bear this risk. This is a business risk that I should be protecting myself for. I should enter into contracts for them. I should have a ready supply of replacement employees. This is my business risk. Now, if we want to put it in terms of the phrasing of the element, this was a basic assumption for me, the house painter, that I would have employees available to do the job. But this was not a basic assumption of the homeowner. The homeowner says, I had no basic assumption about your employees. That is your risk. This is something that I shouldn't even have to think about. When I hire you to do a job, I have no basic assumption about you having adequate manpower to do the job. That's indeed why I'm hiring you to do the job, so I don't have to worry about things like that. All right. Now, often when we're talking about risk and whether the non-occurrence of the supervening event was a basic assumption of the parties, we talk about foreseeability. So here's a little trick though. Don't put the risk on one of the parties, of course the party claiming the excuse, just because the risk of the occurrence of the event was foreseeable, right? Most things are foreseeable to some extent or another. So the question is not whether the supervening event was foreseeable. Ask yourself, was this supervening event so foreseeable? Was the occurrence of this supervening event so foreseeable that we expected this party who is claiming the excuse of impracticability to address this risk somehow in the contract or by taking some other measures to protect herself? If it is so foreseeable that we would have expected the party to address it in the contract or to take some other measures, getting insurance, putting up some sort of protection, hiring extra employees, depending on what the circumstance is, then she will bear the risk of the occurrence of the supervening event. All right, our final element in the doctrine of impracticability also deals with risk allocation between the parties. Should the party who is claiming the excuse bear the risk of the consequences of the supervening event, right? And the rule says that the party's performance will be discharged unless the language or circumstances indicate the contrary, which means, did the language or circumstances indicate that the party claiming the excuse should bear the risk? And once again, we're looking at some sort of risk allocation in the contract, or maybe it's implicit in the circumstances.